Yes, Mr Lancaster.
Commissioner, could I begin with the tender of the statements and associated documents from yesterday's hearing? The team's prepared a list.
Yes.
In the now usual way, I won't specify each of those, but I tender the documents and
Yes,
statements
very
on
well.
that list.
Yes, the documents are received and will be marked in accordance with that index list that you have supplied, and to which I take it the parties have access, Mr Lancaster.
Yes, I asked for that process to be put in place, so I assume it has been.
Well, I'm seeing vigorous nods from the bar table.
I'm not sure about that, Commissioner, but I'm sure we'll get access at an appropriate time. I just wanted to confirm in respect of Assistant Commissioner Cook's statement, you may recall when he indicated it was true and correct, at a general level he identified there'd been some correspondence which corrected, I think, mainly some cross-references. That was conveyed in a letter to the Commission dated 22 May 2026. As long as that letter forms part of the tender, then for the record, that will make it clear.
Yes, no, the corrected form of the statement is the one that's tendered.
I shouldn't have said vigorous nods, Miss Callan. I didn't for a moment think it was assent. I thought it was rather the opposite from yourself and Ms Munro, and I understand that administrative arrangements are being put in place. It's simply that we'd take up the first half hour of the session with me reading exhibit numbers, getting them wrong and being corrected by Mr Lancaster. So if the both of you are content with that, it will be attended to in the course of the day.
Yes.
Yes, thanks, Mr Lancaster.
I call Deputy Commissioner Hudson.
Yes.
Do you swear by Almighty God the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Is that right?
I do.
Yes, do take a seat. Thank you, Deputy Commissioner.
Thank you. Commissioner.
Please state your full name.
My full name is David William Hudson, Hudson.
Thank you. Your address is known to the Commission. You've prepared a statement of 23 April 2026.
Yes, I have, sir.
Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes, they are.
And that will be tendered in due course, Commissioner.
Yes.
You are the Deputy Commissioner Investigations and Counter-Terrorism since 2017?
Correct, sir, yes.
You have strategic responsibility for a number of commands under the New South Wales Police Force, including the State Crime Command?
Correct.
The Counter-Terrorism Special Tactics Command?
Correct.
The Police Prosecutions and Licensing Enforcement Command, which includes the Firearms Registry?
Correct.
And the State Intelligence Command?
Correct.
Among a couple of others?
Correct.
Can I first ask you about the section of your statement where you address funding, as with other officers who have provided statements. Thank you for the written response to these questions asked by the Commission. Question 5 asked about funding, particularly of the counter-terrorism function. You indicate in paragraph 18 that the police did not specifically seek any funding increase between 7 October 2023 and 14 December 2025, but that was because you considered funding and resources allocated to counter-terrorism was sufficient in that period. Is that your evidence?
That's correct, sir, yes.
You refer to CTST, which is the Counter-Terrorism Command, benefiting from an increase over the last 5 years or so.
Yes.
Has that been a year-on-year increase, or could you describe how that has changed?
So since I came into my position, they've had increase in resourcing. In 2017, or 2018, sorry, there was an allocation of 1,500 officers to the New South Wales Police Force by the government. They were allocated based on a needs basis, and Counter-Terrorism and Special Tactics Command did receive resources out of those allocations. Plus, there were additional units attached in that period to the Counter-Terrorism Command. including what was initially the Fixated Persons Unit, but we subsequently renamed that to the Security Investigations Unit, and the Terrorism High Risk Offenders Unit once the legislation had passed by government, plus some incremental increases in relation to movement of commands within counter-terrorism. The Security Management Unit was allocated to somewhere else, but 2 years ago we moved it back into counter-terrorism, so that was another 200 officers that entered the command.
Were you referring there to the last 5-year period, or was that the period immediately after you commenced?
It was around the same time. I think the Fixated Persons Unit came on in mid-2017, but subsequently changed names and was fully integrated into the Counter-Terrorism Command. And the Terrorism High Risk Offenders Unit, I think, was around 2018 as well. But apart from those additions to capability within the command, there's been incremental increases in the number of units based on needs and allocations out of that 1,500 personnel.
Did police identify a need of that sort after the 7 October 2023 Hamas attack in respect of its counter-terrorism work in New South Wales?
It wasn't considered the Counter-Terrorism Command needed additional resources. It was supplemented by Operation Shelter. Some of the work undertaken by that unit that was stood up in October of 2023 in a surge capacity in relation to overcoming what was identified at that time as what the need was.
And the surge capacity would draw on officers from other commands, or how does the surge capacity work in practice?
Yes, it draws from other commands. There's a model built about what numbers are required, and then that is supplemented through a staffing order that is either done through secondment from other commands or on a shift-by-shift basis.
But you've been satisfied yourself that over the last 5 years there has been sufficient funding and resources allocated to counter-terrorism efforts in the state?
Yes, I am, sir. When the threat level was downgraded, we didn't reduce our capability, and subsequently, when it was increased, we didn't have a need for additional resources because we hadn't downgraded the counter-terrorism command with that downgraded threat level.
Thank you. Part of your responsibilities that you've described in paragraph 10 are developing operational strategies, plans and guidelines for effective and efficient policing operations. That's what you refer to in 10A, among other things. And then in 10B, among the responsibilities you identify there are the development and implementation of strategies and plans to build response and capability within the force.
That's correct.
Can I just ask you about one aspect of that, which is risk and threat assessment procedures? The Commission heard yesterday that in 2025 there was no guideline or policy in place that was provided or available to an operations inspector to assist them in making risk and threat assessments in respect of decisions about the allocation of police resources to community events within a police area command at the local level. Can I ask you, do you agree it's important to have a consistent, predictable and thorough approach to making risk or threat assessments for that purpose? In other words, at the local level by an operations inspector who just is day-to-day dealing with assessing the risk of a community event that's upcoming?
The responsibilities I have are particular to the commands that sit under me. I believe that each region has their own process of risk and threat assessment, but I do agree there should be some consistency in that process, and I think the organisation will look at that.
in your view, would a guideline or even a checklist of considerations be a useful resource for operations inspectors or PAC commanders making those sorts of decisions about allocation of resources for upcoming community events?
A process or policy or guideline, as you have suggested, sir, would certainly get consistency in the outcome.
Would also perhaps avoid the risk of busy operations inspectors or PAC commanders, and I'm not referring particularly to the eastern suburbs, I'm referring generally to operations inspectors and PAC commanders, but a guideline or at least a checklist would ensure that consideration is given to all necessary considerations before these important decisions about police allocation of resources is made. Do you agree?
I don't disagree, sir.
Can I ask you about Strike Force Pearl, which you address in one section of your statement? That was established on the 13th of December 2024 to investigate anti-Semitic grievance-based offences in Sydney?
Correct.
How was that resourced and staffed?
Initially it was resourced through the Security Investigations Unit staff and Central Metropolitan Region staff under the leadership of Security Investigations Unit Inspector.
You've referred in paragraph 48 of your statement to its high visibility taskings and its intelligence work, haven't you?
Yes.
Can I just ask you to look in the middle of that paragraph? You refer to Operation Talon style taskings. See where you've mentioned that description?
Yes.
Could you explain what you mean by that sort of tasking?
Operation Talon was an operation designed in 2013 in response to the organised crime environment of escalated shootings and violence on our streets. In essence, it was a saturation type operation where also identified individuals who were known to us, whether they had a firearms prohibition order, may have been checked along that process as well. But that became, it was a surge capability at the time for Talon to overcome a specific need at that time, but has been a model that has been utilised on different occasions subsequently.
So those kinds of processes were picked up and applied by Strike Force Pearl when it had dedicated staffing? Or when
high visibility operations, engagement with the community, engagement with individuals of interest to us.
You've indicated in paragraph 51 that Strike Force Pearl is no longer operating as a standalone strike force with dedicated staffing. So what has there been some replacement function or operation to take its place?
So Pearl was created for a specific reason with a specific terms of reference in response to an escalation in violent behaviour in the eastern suburbs of fire bombings and graffiti that were almost exclusively targeting the Jewish community. There were a number of arrests made in March of 2025. As a result of those arrests, the incidents of that nature disappeared, and whilst there are investigations ongoing in relation to a couple of those incidents and court matters being put before the courts, those responsibilities have been absorbed back to the main investigators rather than a standalone strike force.
But the structure of Pearl seems to involve, and correct me if I'm wrong, but it involved a combination of those high visibility taskings on the one hand, but with a very close relationship with other members of that team who are analysts and intelligence analysts. Is that right?
And detectives.
And detectives.
Yes.
So is that model of a centralised group of intelligence officers, analysts, detectives and high visibility policing something the police regard as a particularly effective way of dealing with anti-Semitic violence and crime?
The responsibilities for Pearl transferred to Operation Shelter, which was the high visibility operation that we commenced on October the 11th, 2023, shortly after the Hamas terrorist attack. So those taskings and high visibility operations were transferred once Pearl had disbanded to Operation Shelter.
So the Operation Shelter model was similar to what you've described as the Operation Talon style tasking and the Strike Force Pearl in its structure? It
was similar, sir. I established Shelter. I was the acting commissioner in October 2023. And following the Hamas attack, I considered that a proactive response was needed to maintain social cohesion. Both patrols of Jewish interests and Islamic interests, a high visibility operation to ensure there was no escalation of violence on the streets of Sydney.
The part of your statement deals with the relationship between New South Wales Police and the Jewish community understood broadly, but also with CSG, the security group.
Yes.
Can I ask you first about the relationship with the CSG? In paragraphs 58 and 59, you acknowledge the important service CSG provides to the Jewish community in New South Wales.
Yes, I do.
And I take it from what you've said in the next couple of paragraphs of your statement that the role of, you have the view that the role of CSG does not and should not supplant or displace the role of the police in protecting all members of the community, including the Jewish community.
Yes, that's my statement, sir.
Yeah. And you identify in your statement that the police would have considerable reservations about granting additional powers or privileges to CSG in respect of law enforcement. Could you explain that view?
So I think isolating a particular group for additional powers within our community is problematic. It creates a disconnect between groups. It can cause friction between groups if one particular element of society is afforded privileges that others aren't.
I can indicate the Commission, and this has been stated previously, is to have a future hearing block in relation to community security for the Jewish community. But I'm addressing your statement because we have you here now. So,
yes.
And you address in paragraph 50, in paragraph 60 and 61, the capacity of New South Wales Police in this regard. The other side of the coin to the reservations you've expressed is, in your view, police has sufficient capacity to be able to allocate resources appropriately if there are enduring threats to the Jewish community in particular. Is that your evidence?
Yes, sir.
Can I ask you question about that part of your statement that deals with information sharing between agencies.
Yes.
Your statement addresses a question from the Commission about whether the New South Wales Police Force recommends any changes to the current authorising requirement for sharing information between Commonwealth and state law enforcement, security and intelligence agencies.
Yes.
And your answer in paragraph 20 refers to the PSPF, which is the Protective Security Policy Framework.
Yes.
That regulates the management of information held by Commonwealth agencies.
Yes.
Now, you refer in paragraph 21 to a variety of agreements and memoranda of understanding between the New South Wales Police Force and various Commonwealth agencies in relation to information handling and information sharing.
Yes, sir.
And those arrangements are, as you explain, for information that's classified, protected or restricted under that framework.
Yes.
Could you address the topic in paragraph 53? That is, what has the police observation been about the nature of information sharing over the time, just at a general level?
Which paragraph? Sorry, sir.
23 is what it... I said 53, I'm sorry. 23.
Yes.
So what have you observed about the information sharing arrangements in their operation?
I have observed different agencies having different interpretations of the PSPF in relation to what is allowed to be shared between agencies. From our perspective, we take a very open interpretation of the PSPF, and if there is risk or threat, we will share information with other agencies. But other agencies can, on occasions, not be so forthcoming.
And has that created a difficulty in dealing with other agencies in terms of the relationship with information sharing?
On occasions, we work through the cases on individual basis, but security classifications around information, getting information to the areas where it needs to be, in my opinion, should be the priority to be appropriately addressed, rather than relying upon the PSPF and as a justification for not sharing information.
So
Deputy Commissioner, you may have already said this, but the PSPF is the Protective Security Policy Framework, is that right?
Yes, Commissioner, sorry, I apologise.
You referred to there being some differences of opinion in the interpretation of the framework. Is that right?
Yes, correct, yes.
And you hold the view, do you, that there should be a review of the framework?
So I think there needs to be consistency across agencies in its application. If that a review is required for that, then yes, I would suggest there should be a review.
So whether or not that sounds in any different expression of the obligations of sharing, it would at least get the agencies on the same page in terms of its interpretation and application.
Yes, sir.
Can I ask you about a more recent operation announced in respect of New South Wales policing, which is the Permanent Rapid Response Team that you deal with in paragraph 36 and following?
Yes, sir.
So why was a Permanent Rapid Response Team announced?
It was a discussion, I believe, between the Commissioner and Government following the attack on Bondi, but also, and obviously relevant to that, in relation to our capabilities, our current capabilities, and what they needed to be moving forward. We have a limited long arm capability within our organisation.
Yes.
At the moment confined to the Tactical Operations Group and the Public Order and Riot Squad. The Public Order and Riot Squad received long arms in 2017, and the current environment, what happened at Bondi and the current environment in relation to organised crime caused discussions in relation to what our capability needed to be moving forward.
There were, before December last year, limited circumstances in which police had long arm weapon capability or possession when they were tasked for a particular purpose. Is that right?
Yes, sir. Different thresholds for the Tactical Operations Group. It was a Region Commander or Assistant Commissioner level who approved special weapons and tactics to resolve a specific situation. And for the Public Order and Riot Squad, it was a Deputy Commissioner who could forward deploy long arms, and the Commissioner had to approve their open slinging of those weapons at an event or in public.
And this rapid response team that I think is to be known as the Armed Response Command, is that going to operate similarly or differently to those other commands that you've referred to that have a current capacity for use of long arms?
The use of long arms will change across the organisation. Deployment of long arms visibly will be a decision by the Commander of the Public Order and Riot Squad, not the Commissioner. It will still be a decision for an Assistant Commissioner to approve special weapons and tactics for a specific situation with the Tactical Operations Group. But the Armed Response Command will have access to their weapons when they are on patrol.
And is it expected that new Armed Response Command team will be in a position to respond differently or more rapidly than on current capability, for example, the Riot Squad or the TOU?
The resources of the Riot Squad are limited and they have multi-functions. Their main purpose of their creation was public order issues, and once they are slinging a long arm, they are no longer allowed to engage in riot control because of if they need to get hands-on with an individual, they can't have the long arm for safety reasons. So it does limit that capability. So they have been used sparingly in that capacity. The Armed Response Command will have dual purpose. It'll be high visibility operations, both static and mobile, similar to models that we have seen overseas about how they are deployed, both in a static mode, potentially at events, but also a roving commission commanded by a 24/7 police operations centre, which will track where those armed response units are and what capabilities are on the streets 24/7.
Does the creation of this Armed Response Command involve any sort of acknowledgement that what previously existed was insufficient in some way, or perhaps I could put to an alternative explanation that Assistant Commissioner McKenna said yesterday, which is just it's a new world since 14 December 2025 in New South Wales?
I think the environment has changed for us, but it's not just the deployment of the Armed Response Command to events, static patrolling. Obviously, on the 14th of December, our police officers were placed at significant risk, being in a gunfight armed with 9mm Glocks against long arms. There has been, obviously, on behalf of officers within the New South Wales Police Force, representations made by the Police Association of New South Wales, their union, in relation to what capability increases can better protect them as well, their officers, their members. The availability of long arms on a more frequent basis is certainly a response to that, and also better protection of the community. So it's twofold.
The title of the new command, Armed Response Command, suggests that it will be responsive to incidents, but is it intended that that would also be deployed proactively? In other words, to address an upcoming event rather than just being responsive to an incident?
Both, sir. They will do static guards or static presence at events, but they will also do mobile patrolling within certain sectors, monitored through a police operations centre to ensure appropriate coverage over the most required areas. Incrementally, the Armed Response Command will replace the responsibility of shelter, which is currently in operation, and become a permanent fixture rather than a surge capability that shelter has become.
And you indicated in your statement it will comprise 250 additional positions. So the command itself will be comprised of those 250, or did you mean to suggest that it will be 250 additional to something else? 250
will be the strength of that command, the frontline presence plus the command structure plus intelligence officers which will be deployed to that unit to ensure they are deployed appropriately.
You indicate an expectation on the part of the force that formation of the new command will take between 18 months and 2 years.
Potentially less than that, sir.
Why that sort of time period?
There is a training regime that's required for training of police in long arm capabilities. At the moment, we have trained our weapons trainers in long arm training. That's been taught by the Public Order and Riot Squad trainers and the Tactical Operations Group trainers to our general weapons practitioners. So there's a number of those officers being trained at the moment, so they can train the greater cohort. Once an individual is selected or identified for a position within the Armed Response Command, there's a minimum of 10 days training in familiarisation with a long arm, plus the tactics involved in that, especially integration with active armed defender training and how a long arm deployed to an environment which is currently where there is activity with general duties police armed with a Glock, and how that interoperability impacts. There's a lot of training in relation to that. So it's expected that incrementally, probably at 50 individuals per graduation class, that can backfill the places that these officers will come from, that command will be built probably over the next 12 months now. We've escalated that process. And as that command is built, shelter will reduce, the responsibilities for shelter will reduce, as those responsibilities are taken up by the Armed Response Command.
Thank you.
When the Armed Response Command is at full strength, how many armed frontline officers do you expect it will have?
In excess of, just in the Armed Response Command?
Yeah.
210, I think the numbers are at the moment.
And they will have a number of vehicles so that the command could have resources, that is frontline police officers with long arms at several events or incidents.
Depending on the risk framework and the threat assessments conducted of different events, yes, that's correct, Commissioner.
Can I ask you now, Deputy Commissioner, about your response to a question about the effectiveness of the national counter-terrorism framework, and in particular the management of risks posed by persons who have come to the attention of intelligence or law enforcement in the past.
Yes.
Part of your statement deals with that and refers to the known entity management model that's
Yes.
applied. Now, it's right, is it, that any person who has come to the attention of intelligence and law enforcement agencies in respect of terrorism at some point in the past, as you say in your statement, but is not currently under active investigation or monitoring, is placed on this known entity management model list?
In New South Wales, sir, yes, I
New
can't
South
speak for the other
Wales.
states.
Yeah. And there are various tiers of that model according to the nature of the individual concerned.
That's correct, sir. There are 4 tiers.
And what's your view about the effectiveness of a known entity management model for policing in respect of counter-terrorism?
Prior to the creation of the known entity management model, there was no way of retaining information in relation to specific people of interest to us that had been of interest to us previously. I think a constant assessment of individuals, certainly in the first 3 tiers, as to what their current activities are, what their current personal situations are, and whether they are likely to be problematic to us as individuals, is certainly valuable. I was instrumental in the development of the known entity management model in 2017, based on occurrences that had historically occurred in New South Wales, but also around the world, of individuals who had previously come under the notice of counter-terrorism police, had been discarded as appropriate suspects, but there was obviously some residual risk as they had gone on to commit offences. So within my jurisdiction, I discussed with the commander of the Counter-Terrorism Command what I referred to as residual risk of these individuals and how that was to be captured and monitored.
And so if an individual comes to the attention of New South Wales authorities in respect of terrorism or suspected terrorism, and is placed on the list at one or other of the 4 tiers, what in broad terms then would occur under the model if there's new information about that person that comes to light subsequently?
There'd be a reassessment of that individual based on the information that came in under the notice of police, came to the notice of police, to see whether they were worthy of additional activity, investigative activity by us.
Thanks, Deputy Commissioner. I don't have any further questions.
Deputy Commissioner, can I just ask you a few questions
Yes,
about
Commissioner.
Operation Shelter
Yes.
to see if I've got it right? On the 11th of October 2023, after the Hamas attack on Israel, you perceived the need for additional resources to provide protection to the Jewish community.
Commissioner, not just the Jewish community, but reprisals against the Islamic community as well.
I see.
So some of the taskings were certainly committed towards places of worship for the Islamic community as well.
Yes. And at that time, do I take it that Operation Shelter had a number of police officers attached to it with taskings that related to protection of those communities?
Yes, Commissioner. It was a surge capability. The resources were obtained from other commands and temporarily seconded to Operation Shelter under the direction initially of Assistant Commissioner Scott White.
So Operation Shelter was a police operation that had the capacity to surge resources from other commands when it was considered necessary for the protection of the Jewish or the Islamic community. But would it be right to say at times that capacity reduced to nil?
Not initially, Commissioner. When we initially established it, I think there was over 200 shifts per day were allocated that shelter had to attend certain taskings, certain places of interest of both the Jewish and Islamic communities, plus patrolling other sites based on intelligence and intelligence, what that was coming into Operation Shelter. It had an intelligence capability as well. It was also important for us to document and record all those interactions and taskings, which were certainly done through spreadsheets maintained by Operation Shelter at the Police Operations Command.
As I understand it, after the arrest of those individuals charged with offences by Operation Pearl, it appeared that the incidence of violent attacks on buildings within the Jewish community reduced notably. Is that so?
Yes, Commissioner. It was identified through investigations that those incidents have been orchestrated by a limited number of people upon direction of others, and once we went to resolution phase on those individuals, those highly brazen attacks disappeared.
So that what was the position by mid-December 2025? Was Operation Shelter active? Did it have many police resources attached to it or not?
Operation Shelter was under the direction of field operations, not my area.
I see.
But I know that the response was absorbed by the Central Metropolitan Region for the management of protests and any proactive taskings that fell to Central Metropolitan Region, rather than a centralised group where resources were taken from other commands to staff it.
So that in effect, Operation Shelter at that time was no longer functioning.
In name only, as a capture process, I believe, for reports and certain deployments at local level by commands, but not a centralised group that was deployed centrally across Sydney.
And since the attack on Bondi, has Operation Shelter been reinvigorated, if I can put it that way?
Certainly, Commissioner, it's been in effect since very shortly after December the 14th.
And the intention is that it will remain an active policing resource until the Armed Response Command becomes operational.
That's correct, Commissioner. As I indicated, the Armed Response Command will be built incrementally, probably at 50 officers per attestation class at this stage. Next year there are 4 classes. There's 2 more classes this year. So when those resources, those attestation classes graduate and we get more police from those classes, officers will be released to the Armed Response Command so they can be replaced by these new probationary constables, so that the operational effectiveness of the commands they come from at the front line are not impacted.
What is the capacity as at today of Operation Shelter in general terms?
My understanding, and we recently did a review of that, there's an acting assistant commissioner in charge of it at the Police Operations Centre. I think it's 150 officers per day at this stage are currently deployed across Sydney. That has varied from 250 to 150, but at the moment I think it's about 150 officers.
Thank you, Deputy Commissioner. Ms Munro?
Yes, thank you, Commissioner. I just have a couple of questions arising from paragraph 43 of the Deputy Commissioner's statement. Deputy Commissioner, if you have that paragraph to hand, you'll see it refers to 2 monthly teleconferences of the Deputy Commissioner's monthly hate crimes meeting. Do you see that paragraph?
Yes, I do. That I attended, yes.
Yes. And can I, Commissioner, just show the witness a document? And I have copies of that document.
Yes,
I ask
by
that it
all
not be
means.
brought up on the screen if that's
Court
possible.
officer?
For the record, the document
I withdraw
is,
that. Commission officer.
the document is AFP 0028 0003.0025, and as I say, it's not to be brought up on the screen.
Yes.
Thank you.
Deputy Commissioner, you see the title of that document is Deputy Commissioner's Monthly Teleconference Hate Crimes Meeting Minutes,
Yes.
and that the date of that document is 19th September 2025.
Yes, I do.
And you see the attendees, and there are a number of them, including yourself, noted as an apology.
That's correct.
And you would agree with me that notwithstanding that you didn't attend, that meeting, so far as this document demonstrates, took place on the 19th of September 2025?
Yes, I don't dispute that.
And at agenda item 2, you see that there are confirmation of minutes from the previous meeting, and there it states that the minutes from 1 August 2025 meeting were endorsed.
Yes.
And sitting here, you don't recall if you attended that meeting.
My recollection is I attended 2 meetings. These were meetings that were put on without consultation with the jurisdictions, and on a number of occasions I could not make those meetings. I had other responsibilities I needed to attend to.
I understand. Thank you. Thank you, Deputy Commissioner. Those are my questions, Commissioner.
Thank you, Ms Munro. Ms Callan? One moment, please. I think, sir, you are for the Executive Council of Australian Jury and the other parties?
Yes, Commissioner.
Yes. Do you have any questions?
No questions.
Yes. Ms Callan?
No questions for the witness, if he could be excused.
Yes, indeed. Nothing arising out of my questions, Mr Lancaster?
Nothing rising. Thank you.
Yes, very well. You are excused. Thank you, Deputy Commissioner.
Thank you.
Commissioner, whilst it's fresh on your mind,
Yes.
noting there are 2 topics that were raised with this witness. One was in respect of the desirability of a guideline or other process at the PAC level in relation to assessment of risk.
Yes.
But I just note and draw your attention to the evidence in Assistant Commissioner McKenna's statement at paragraph 40. That statement has the doc ID STAT.899.0033.0002, and I'm pleased to be able to indicate it's been marked Exhibit 2-035 with the benefit of a list that's been circulated to the parties.
Thank you.
What Acting Deputy Commissioner McKenna says at paragraph 40 of his statement is that he refers to a risk assessment process that's been in place for some time with New South Wales Police, specific to search warrants and firearm prohibition orders, but to enhance consistency, the development by New South Wales Police of a form of that model which is to be utilised for all operations which require a documented risk assessment and would apply to proactive taskings where it's determined that a documented risk assessment is warranted. It's not a complete answer to the point,
Yes.
but I would just remind the
Ms Callan, that is very helpful.
the other thing is, whilst I'm on my feet, in terms of the questions that were asked of Deputy Commissioner Hudson about Operation Shelter,
Yes.
and your questions, Royal Commissioner,
Yes.
again, if you turn to paragraph 70 and following of Assistant Commissioner McKenna's statement, he addresses the rationale and purpose for the creation of Operation Shelter. He annexes a timeline of Operation Shelter as it escalated and de-escalated, including explaining the position as at mid-December 2025 and what's occurred since 14 December 2025.
Thank you again, Miss Callan. That is very helpful. Yes, Mr. Lancaster.
Commissioner, might now be an opportunity that you would be willing to take a short adjournment just before the next witness. There are a couple of things just for me to deal with before that occurs.
Yes, indeed. Are we talking of a very early morning tea, Mr.
I think we are,
Lancaster?
yes.
Well, I'll take up that suggestion. I'll take a 15-minute adjournment.
Royal Commission on Antisemitism, Social Cohesion is now in session.
Yes, Mr. Lancaster.
Commissioner, I call Assistant Commissioner Hayward.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do. Thank you. Do sit down, Assistant Commissioner.
Assistant Commissioner, please state your full name.
Kirsty Marie Hayward, Heyward.
Your address is known to the Royal Commission, and you hold the position of Assistant Commissioner, which you have since February 2025.
Yes,
You're the Commander of Police, Prosecutions and Licensing Enforcement Command,
I am.
and that includes the Firearms Registry.
It is.
Now, as I'm sure would be etched in your mind, the Firearms Act contains in Section 12 a restriction on the Commissioner issuing a licence that authorises possession and use of a firearm unless the Commission is satisfied that the applicant has a genuine reason.
Yes.
And the Act provides for an applicant having a genuine reason in certain categories of case. So if an applicant declares that they are in that category and then proves that they are, that can satisfy the genuine reason requirement.
Yes.
One way to substantiate a genuine reason is to be a member of a hunting club and to meet certain requirements.
It is.
Another is recreational hunting and vermin control.
It is in terms of permission to shoot on a rural land or a rural landholder.
What broadly do you, as the commander of the registry, see as the rationale for those requirements in the Act?
In terms of the genuine reason?
Yes.
So a licence applicant needs to, I suppose, in terms of the overall principles of the Act, we talk about firearms possession and use as being a privilege, which is conditional on maintaining public safety. And so that's a starting position. In terms of genuine reason, is linked to the reasons for which a person who is applying for a licence says that they're going to use or possess a firearm for that particular reason.
And just to perhaps go back a step, when somebody applies for a licence, their first step would be to do an approved gun safety course and to get a certificate in that respect.
It is.
And then to compile their reasons, compile their proof of their genuine reason for having it, and then to make the application with that supportive material.
It is.
And the process then becomes one where, as you've described in your statement, there are 5 teams within the Firearms Registry.
There is.
And the first of those teams is the one that receives initially the application, which is described as the customer service team.
It is.
Yep. And they perform an initial review, a check of the information.
They do. They validate the criteria in terms of the application. So 18 years of age, the form, which is prescribed by the regulations. And then they also validate the genuine reason, and the firearm safety training course has been attached, or the completion of has been attached. And that's the first part of that validation process.
Yep. And that process you've described is carried out by staff of the registry who are not in the adjudication team, who are not adjudicators?
They're not adjudicators. So the customer services, there's a customer service team that deal with that. I suppose we call it the very front end of the application process. And there's some automated processes within that. And then if a flag arises in terms of record, criminal record, intelligence, etc., it then moves over to the adjudication team.
The members of the customer service team, that first level of staff review of an application, they are not trained in the same way that an adjudicator might be trained. Is that right?
They have the same initial training, and then adjudicators get further and ongoing training in terms of the parts of their discretionary decision making, which is more relevant to their role.
And is one of those additional aspects of an adjudicator's training what's referred to in your statement as the intelligence fundamentals module?
It is.
So the staff in the customer service team don't get that intelligence fundamentals module training, is that right?
I don't think so.
Now, the staff members in the customer service team do have the ability to approve or refuse applications themselves, is that right?
They do.
Yeah. You've referred to flags. If a flag comes up, they are expected to refer an application to an adjudicator for further assessment and analysis.
Yes.
But that process of referring a matter, an application to an adjudicator is a decision made by the registry staff member from the customer service team.
It is. For new applications and renewals, it is.
Is one limitation of that structure that the customer service team person is relied on to identify an actual or potential issue with an application in circumstances where that individual does not have, for example, the intelligence module training to be able to identify an intelligence problem?
No, so the adjudicators assess the information. The customer service team identify that something exists, don't assess it, they move it straight over to the adjudicators.
Right, so if the collection of information by the staff member in the customer service team identifies any sort of intelligence-related issue, that will, as a matter of course, be provided to the adjudicator, is that right?
It will. So the first, we call it 3 line items, and that's part of the automated process. So there's a line item that goes to the criminal history unit within our organisation. They do the national criminal history check, they do the national intelligence check, and they also do a check on our custody management records to indicate if there's any information on there around drug use or mental health, right? They then provide back to the customer service team whether or not any of those checks have come up with anything.
And does the customer service team member in that position who receives something back from one of the 3 lines that you've referred to, is it then a matter for the discretion of that person whether or not to refer the application to an adjudicator?
No, it's not discretion. So it's a must if anything comes up in any of those 3 checks. And then our state intelligence check of our own intelligence, if anything comes up, it goes to adjudicators.
So is it the position or not the position that the customer service person could say, oh, that looks all right to me, I'm going to approve the application?
No.
That would not happen?
No.
Now, the next process in an application where an application is referred to an adjudicator is consideration by the adjudicator of the information that's come to light.
Yes.
Now, what you've referred to the three lines, and in paragraph 73 and following of your statement, you refer to the process by which adjudicators within the registry obtain intelligence about an applicant. Could you just briefly describe that part of your statement?
Yes, sure. So Chimera is the system. It's a web-based system. It's a decision-making tool. It was originally created in our organisation for intelligence officers, and then it was enhanced for firearms registry staff, particularly in relation to sourcing information from our other systems. So it does that, so they don't have to, as a starting position, check multiple different systems. And then it also has been enhanced so that they can document their decision making in that document.
And you've indicated that Chimera draws on the COPS database information.
It does.
And other sources of information available to New South Wales Police.
It does.
And is that just a firearms registry resource, or is Chimera more widely available in the force?
Chimera, as it was originally built, is available to intelligence officers, say in police stations, to build profiles for people. For the registry, it's used as a decision-making tool. But it automated that process for them somewhat.
There's a third team in the... I'm sorry, before I go back to the third team,
Sorry, can I just further to that answer?
Yes.
So I explained Chimera, but they can also then use their own individual COPS profile to log into our police systems or other systems if they want to delve deeper into a particular intelligence or information report or a charge or a COPS event. They can do that. And then thirdly, the other way that they can gain information is by sourcing that from specialist units, for example.
So they can make direct contact. I think one of the examples you give is the Counter-Terrorism Special Tactics Command. They can make direct contact with officers in that command to ask for information.
Yes.
I was going to then take you back to paragraph 32, and the third team in the registry is described as compliance and enforcement team.
It is.
What's the function of that team?
It's multifunctional. One part of it is to assist the registry as a business unit in chasing up requests made to other police for information. They also conduct and plan, coordinate audits of dealers and clubs and ranges, and ensure, I suppose, compliance in those in the firearms legislation in regards to those.
So if an adjudicator, for example, has sought to follow up something that's been seen on Chimera and makes an inquiry of some other command within New South Wales Police, how do the compliance and enforcement people come to learn of that and learn that they have to follow it up?
So the registry, we use the Integrated Licensing System, ILS, and in ILS there's different codes for where work can go, or a case or an application can go. So an adjudicator, if they have sent out a request for information to police, they will put it into a certain status code. Status code 05 is used for that purpose. The compliance and enforcement team manage the matters within status 05.
So their duties day to day are to identify items with that status and then follow that up administratively with the other commands to make sure that a response has been given to a request.
Yes.
One circumstance in which an inquiry might be made of another part of New South Wales Police is if the adjudicator or intelligence analyst in the registry can't view information.
Yes.
Can you describe the circumstances in which that might happen?
So, as I said before, the adjudicators use the Chimera decision-making tool. In a sense, that provides the adjudicators with access to information up to and including protected within our organisation, unless it's put on the system by a unit in another classified way for which they can't access. There is a restriction on that though, in that intelligence reports placed on our system prior to 2015, the adjudicator will be able to see the title of the report, the date, I think the subject matter, and the admiralty rating, but they won't be able to see the narrative. So that's a restriction in the Chimera. So then they would need to go into COPS and see if they can, through their own profile, access that information report. If then they don't have the necessary intelligence profile to give them access to that, that is when, or a warning comes up, or a flag that says you can't access this. If you need information, please contact, it might be counter-terrorism or it might be State Crime Command or whatever, and that's when they'll make that inquiry.
Yeah, so that would be something that the compliance and enforcement people do, or would the adjudicator make that follow up to a different command to say, there's information I can't presently access, what can you tell me about it?
The adjudicator.
The adjudicator would take that step. Does that put the adjudicator in an awkward position in the sense that the adjudicator is meant to be doing the analysis of the information, but will need to turn to another command or officers from another command to understand the information that's relevant to the application?
It depends what the request they are making. Generally, they will ask for the information contained in that report or a summary, so then they can assess that information.
And would, in the usual course, would the information or a summary of it be provided, or would it depend on the classification of the?
It would depend if there's a open investigation. It would depend on the person, I suppose, who receives that request.
Yes. Now, in relation to the use of Chimera, as I think you've explained, it draws information from a number of New South Wales police systems, and it draws that information regardless of security classification. Is that right?
Yes.
Yeah, in that Chimera is intended to identify the existence of the information, even if it doesn't have the content of it immediately available.
Correct. So it's built on a need to share basis or a philosophy rather than a need to know. So that's why I suppose it provides that capability to the registry adjudicators.
And is part of the reason that that structure has been adopted is it's important for firearms adjudicators to be able to either see the information for themselves or see for themselves that information exists relevant to the application.
Yes, that's correct.
Now, you've explained in paragraph 72 of your statement, that of your first statement, and I perhaps realised I didn't identify your three statements at the start of your evidence, so I might do that in a moment, Assistant Commissioner. But in paragraph 72 of your first statement, you say that out of administrative necessity, the registry adopts what you'd call a next-in-line structure, whereby adjudicators perform work on applications on a next-in-line basis rather than taking ownership of an application from start to finish.
Yes, and I think that was relevant to the period of time mostly from when I suppose Chimera came into place for the registry adjudicators, but then also over a period of time where there was a backlog of work to be completed. It is now the case though that we will be trialling a cradle to grave case management, and I suppose linked to that we're also making inquiries with GunSafe, and I haven't spoken about this yet, but I don't know if we'll get there, but GunSafe is another system that the registry uses. It's an out-of-face system though, in terms of interaction with customers and dealers, etc. To see if there's capability within that system for a case management allocation module.
Did you describe GunSafe as an out-of-face
system? It receives information
Yes.
as an interface, and then it does update some of our systems, but there is still limitations that I know of, which we're exploring to see what else it can do.
Thank you.
Just to go back in to the issue of continuity in the handling of applications, you mentioned that there's a proposal, is there, to trial what you've called cradle to grave handling?
Yes, so they're going to trial it immediately, and the way they have to do it, though, I think, is by way of the Chimera reports, and they still use a spreadsheet to see who's allocated matters. So, it's a bit clunky. Obviously, it's not ideal, but we're going to see if we can manage a cradle to grave component of that part of the business, because then it does reduce duplication, and we're talking about efficiencies, and it does then create total ownership of decision making, and so that's why we're keen to trial.
So the structure of it that presently exists and that has over the last many years is that it's common for multiple adjudicators to be involved in assessing a single application?
It was probably up until maybe the end of 2023. I think from that stage, different modules of GunSafe came online, and with each module that came online, it created, I suppose, human resource savings, because there wasn't the need to manually do some task. So as the different modules came online, it gave back more time to the adjudicators, for example, and then I think we assess that now they're in a position to trial it now.
Yes. In terms of the previous structure or the existing structure, that is a model that requires adjudicators to be particularly diligent in terms of record keeping as to every particular stage of the application assessment, so that if a new or different adjudicator comes in at a later stage of the assessment, that later person knows precisely what's happened in the course of the application.
That's the absolute expectation, yes.
And the existing model, which has been applied for a number of years, also depends on that later person having the time and diligence to look back at the file to determine precisely what has occurred on a particular application.
Yes, that's correct.
Is one advantage of the proposed trialling of the cradle-to-grave process that it ensures that there is one adjudicator who's looking at the application holistically and who's aware of each stage of the application process?
Yeah, that's definitely one of the benefits that we see. Yeah. And like I said before, ownership and decision making as well. And I suppose efficiencies in terms of how we use our workforce.
And was one limitation of the next in line assessment process was that it did create some risk that there might be a slip or a miss of information in between the assessment of different adjudicators along the course of any one application consideration?
It has potential, yes.
You've referred to the introduction of some key performance indicators in paragraph 54 of your first report, which were introduced in section, withdraw that, introduced in 2021.
Yes.
Could you explain what those indicators are that were introduced?
So generally speaking, and they're published publicly.
Yes.
They outline the average time it takes to complete certain licensing tasks within the registry.
Yes.
And it depends, I suppose, what average time is set as a KPI to be within that time frame. That is what is considered then, I suppose, a positive outcome that the performance is being tracked, and that they are maintaining that certain performance level.
Yes. In terms of the average processing time for new licence applications, for example, for category A and B licences, do you have those sorts of figures in front of you as to the time that has taken in
currently, or
2019 to current?
I think they're in my statement. If you
would you identify those?
Of 131. So in paragraph 131, I identify the processing days for 2020 through to 2023.
Yes.
And that's for new applications and renewals.
So
yeah.
They're the actual figures rather than the performance indicators, right?
Yes.
Yes. And that sets out for each of those years the processing time for licence applications and renewals.
Sorry, I just missed that last bit.
that sets out for 2020 through to, I think you've got through to 2023 of the average processing times for applications and renewals.
Yes.
And you'll see, for example, in 2020, about a third were processed within 44 days, and about 87% were processed within 120 days.
Mm-hmm.
If you add those first two categories.
Yes.
And then in 2021, about 40% were processed within 44 days, and about 90% were processed within 120 days.
Mm-hmm.
So the vast majority of them in each of those years you've identified were within 120 days.
Yes.
A substantial proportion of those, about a third or 2/5, were within 44 days.
Yes.
Before I continue, I will attend to that matter that I'm sorry I overlooked at the start
Perhaps
of your
before
evidence.
you attend to that housekeeping matter,
Yes.
I will just note that, as I understand it, Ms Sharp, you now appear for the Commonwealth.
Yes, I do.
And
I vote for New South Wales.
Oh, I'm sorry. Yes, thank you, Ms Sharp. And Ms Lynch, I think you are appearing pursuant to my grant of leave to the Shooters Union.
Yes, Kirsty, I appear for the record Lynch EA. I appear with Edwards.
Yes.
Online. I can't see her.
I see. This is a brave new world for me. I understand we have Ms Edwards of Senior Counsel on the AVL, but we can't see you, Ms Edwards. Do I take it you can... you have appeared miraculously, and you have had no difficulty in following the proceedings thus far?
Yes, I've been able to see this witness, Commissioner. I couldn't see the last witness, but I could hear him.
Right. That's good, Ms Edwards. I indicate that the grant of leave to the Shooters Union includes the grant of leave to examine the present witness in relation to evidence given in this public session, but does not extend to any evidence respecting firearms licensing given in the closed session. Yes, thank you. I think we're probably about to lose you again visually, Ms Edwards, but you will no doubt be able to let us know if there's any difficulty as far as your capacity to see and hear the witness for the balance of her evidence in chief. Yes, I'm sorry, Mr Lancaster, you were about to tender the statements.
I am. So, Assistant Commissioner, your first statement was dated 29 April 2026. Your second statement dated 5th of May 2026. Your third statement is dated 20th of May 2026. The contents of each of those statements true and correct to the best of your knowledge and belief?
They are.
I tender those statements, Commissioner, and they'll be included on the list that will be prepared.
Yes, and might I take it the parties with leave have access to those statements?
Yes, with the qualification that there has been some redaction of material in the material provided to the shooters.
Yes, and indeed, that's the material that I've been given.
Could I ask, I'm sorry to interrupt, Commissioner, but,
Yes.
but the passage of examination that has just fallen from Mr Lancaster entirely was part of the redacted part of the statement that we had received. Will we be receiving an unredacted version of the material that at least has been put now as part of the public hearing?
Well, I don't doubt we can arrange that, Ms Edwards, but it is part of a public hearing. I don't know whether you or Ms Lynch had an opportunity to make a note of it, but it's material upon which obviously you can examine the witness, and if you like, we will arrange for a further copy of the statement with that portion unredacted in due course. But For the present, Ms Edwards, I propose that we continue.
Thank you, Commissioner.
Yes.
Commissioner, without unduly interrupting, may I have the opportunity to take instructions on whether a further redaction can be provided?
Well, Ms Sharp, what I am offering Ms Edwards is that the Commission will make available a further copy of the Assistant Commissioner's statement containing a paragraph detailing information that has just been given publicly and live streamed. Does New South Wales have any objection to that?
It's only the opportunity to see. I don't imagine there will be an objection, but just the opportunity
Ms
to
Sharp,
see first.
what will be made available to Ms Edwards and her client is no more than material that has been publicly given in evidence and live streamed.
Yes, on that
That's the
understanding.
basis of the redaction.
Thank you for that
Yes,
clarification.
very well.
Assistant Commissioner, can I take you to the part of your statement that you deal with the guidelines that are issued to registry staff? And you referred to these in paragraph 67 of your first statement and the following paragraphs. Do you have that?
I have 67.
You refer to the guidelines having been amended in March 2026 following amendments to the Firearms Act, which were themselves a result or a consequence of the events at Bondi in December last year. Can you identify what, if any, real amendments of substance have been made in terms of the guidelines? Are you in a position to be able to speak to that?
I can. I suppose I just have a question if that Commissioner would be evidence given in closed court or not.
Oh, I see. If there's a concern about... so my question is just for you to address in the broad any topics on which the guidelines have changed in substance as a result of the recent amendments to the Firearms Act and more recent consideration in March 2026.
So there is, in terms of the amendments to the Firearms Act, there was a section included in relation to the issuing of permits to acquire.
Yes. And guidelines have been amended to reflect
The changes in the legislation which have been enacted.
and any other topics on which there's been any substantial amendment?
I wouldn't say substantial, but I do wish to discuss further. But
Yes.
I'm of the view that it should be in closed court, only in a sense because they identify direct changes.
Yes. No, I propose that the Commission should accommodate that request, and you have agreed to give evidence later this week in closed session.
Tomorrow.
Yes. Now, can I ask you about the intelligence capacity of the registry in terms of the intelligence resources and analysis that it can call upon? Mm-hmm. There have been some changes to the way intelligence has been both staffed and assessed during the last 5 years or so.
There has, yes.
There was a senior intelligence analyst within the registry between the 1st of June 2015 and 12 November 2021.
There was.
and that position then did not exist from November 2021 for a couple of years?
To, I believe, March 2025.
Yes. So is the position that there was an approval granted to reintroduce that position of senior intelligence analyst? The approval was given on 27 December 2023, but the position wasn't actually filled until February 2025.
That's correct.
So for that period between November 21 and February 25, the previously existing senior intelligence analyst position just didn't exist within the registry. Is that right?
The position didn't, no.
Position didn't. Do I take from your answer that you consider the function was picked up by some other staff members?
There was multiple parts of that function. I suppose split between different business units in the organisation or the registry. So there was a team in the registry which reviewed pendular intelligence hits, which was previously a role, I believe, of the intelligence officer. And there was arrangements made with State Intelligence Command in terms of other aspects of intelligence.
Right.
Sorry, and there was also police officers in the registry at the time the position was moved who had intelligence experience.
Right. Perhaps I'll just ask you a little more about that in a moment, but just coming back to the present arrangements in 2026.
Mm-hmm.
So the intelligence analyst position was restored and then filled in February 2025. And then is it right that in February 2026 there were 2 additional senior intelligence analysts attached to the registry?
There was in March, I believe.
And that there is also now a position of intelligence supervisor within the registry?
There is.
So
There's three together at the moment. One's permanent and 2 positions are temporary for 12 months.
And so going forward,
Mm-hmm.
how many dedicated staff who are intelligence analysts are there intended to be within the registry?
3.
One of those is the intelligence supervisor and then 2 analysts?
Yes.
And they are all to be there devoted full time to that
Yes.
task? Can I take you back then to 2021? You describe in your statement this is your second statement of paragraph 12. You identify that in January 2021, the Beatson Review recommended a realignment of the structure, roles and responsibilities within the Firearms Registry.
The Beatson Review outlined, I think it was 8 recommendations.
Yep.
One of those recommendations, 2 are relevant. One was to create a business improvement team, and the 7th recommendation was to review the structure and roles within the registry.
Yeah. And the recommended business improvement team itself, it came to exist and then developed recommendations to implement the review, and part of that was a recommendation that the intelligence analyst role was thought to be underutilised, only reactive, and duplicated the work of the adjudicators. That was the view at that time.
That was the view that I obtained from documents.
Yes.
In response to summons.
Yes. Your second statement in paragraph 13 indicates that the intelligence analyst was in effect repurposed to be a business or management analyst dealing with performance trends and workforce planning.
Mm-hmm.
You accept that was a very different position. It didn't
It's a different
contribute
role.
to licence decisions. It was distinct from a licensing decision.
Yes, it's a totally separate role.
Totally separate role, yeah. As you've just referred to in evidence, the intention was that the State Intelligence Command could be drawn upon for intelligence information to satisfy the needs of the registry during an application assessment. Yes.
That's correct.
Now, did that was that a formalised structure, or did that depend on ad hoc contact by an adjudicator with the State Intelligence Command?
I haven't been able to find any documented formal structure. There was perhaps a Teams channel created on our police system, on the police system for communications, but I haven't been able to obtain anything.
You also say in paragraph 13 that these changes led to or were accompanied by extensive internal consultation.
Yeah, so for any restructure in our organisation, a component of that involves consultation, whether it be with the police association and staff or yeah.
And are you aware that the feedback that was received at the time included concerns being raised about the Firearms Registry losing the intelligence capability from its internal source to being dependent on approaching other commands?
I've read the feedback provided during that consultation.
And you've identified feedback of that character?
Yes.
And then the changes for the removal of that intelligence analyst position were then approved in August 2021, according to your statement?
Yes.
Then, during 2022, a submission was made for Firearms Registry staff to receive training and approval to make decisions based on criminal intelligence. Is that right?
Yes, I've read that.
Yeah. But before that time, before 2022, they weren't authorised to do so, and intelligence matters needed to be referred to the State Intelligence Command.
Yes, and I believe they're referring, from a recollection of the document, in terms of matters for which refusal or revocation is required by the Commissioner.
Yes. Now, in February 2023, going forward, as you say in paragraph 14 of your statement, there was, you understand there was an issue raised by the then manager of licensing services at the Firearms Registry, which identified several intelligence practice capability gaps.
Yes.
I think the word in your statement is numerous intelligence practice capability gaps.
That's what the report outlines.
That's what the report did, yeah. And in April 2023, there was a further issue raised by the then manager of licensing services at the Firearms Registry, which asserted that there were risks to public safety due to capability gaps at the registry as a result of there being no dedicated intelligence resource to support the functions of the command.
Yes, that's what the report says.
That's what it says. Was it the fact that the manager who was raising these issues was performing some of that intelligence support on an ad hoc basis because he happened to be trained in intelligence? He was
trained in intelligence, and I believe he was doing maybe a component of that. I can't confirm exactly what it was, other than I think assistance with obtaining access to certain information reports.
The commander of the registry at the time agreed and noted was considered a significant risk to both public safety and the New South Wales Police Force that this command has no in-house intelligence capability.
That's what their report says.
You didn't form your own judgment about that, you're just recording what the report says.
I was just, I wasn't the decision maker at the time. I wasn't the commander at the time. I'm aware that Assistant Commissioner Cook gave evidence yesterday in terms of his reasoning.
Yes.
So I've just outlined what I've observed in the documents.
In the documents that you've reviewed. Yes. Thank you. And so then a proposal was made and approved to reinstate an intelligence position at the sergeant level in late 2023 in the registry.
It was.
And you've in paragraph 16 you've withdraw that. In paragraph 17 of your second statement, then you outline a number of tasks that were being undertaken by the intelligence analyst. And at paragraph 18, you identify a number of benefits of having an embedded intelligence capacity within the registry. From your review of the documents, do you agree that that intelligence analyst position should not have been removed when it was for a number of years?
I can understand on the base off the back of the review and the assessment made of the business improvement team why the decision was made, and I'll just explain how I see it. And again, I say I wasn't the decision maker. There was an assessment made of what that role was providing to the command at that time, and it was obviously assessed that what was being provided to the registry wasn't, I suppose, didn't establish the need for a full-time intelligence role in the registry. And then coupled with that, I understand that around the same time, a chimera, as I've explained earlier, was enhanced for adjudicators. So they had then access to information, which their role is to assess information, whether it be intelligence reports, charges, COPS events. And they also were required to do the PEAT fundamentals, intelligence fundamentals course, to support that from a basic intelligence awareness. So I can understand in terms of the business at the time why decisions were made and then arrangements made for different parts of those tasks. I'm just not sure though if at some point in time along that line those arrangements might have not come to the ultimate fruition. So from my understanding, for example, State Intelligence Command provided some support in terms of the Section 11.5 capital A refusals or revocations for which need to be revoked or refused by the Commissioner. And so I can understand, I'll go back to that, I can understand when you look at the business at that time why that decision was made. And then I can also understand for the business now why it's been reintroduced.
as the present commander of the command that includes the registry, is it your view that the present arrangement with in-house intelligence analyst capability is clearly the preferable model for the way firearms registry staff should deal with intelligence in terms of an application?
Yeah, and it's directly, it is, and it's directly relevant to the business that they are undertaking and anticipation of additional work that they will do once some amendments to the TOLA legislation are proclaimed.
So do I understand you to say that the present position where there will be 3 full-time intelligence analysts in the registry, that is also to accommodate some future amendment or change in the way or in the processes for dealing with intelligence by the registry?
Yes.
What's expected in that respect?
So, as I've explained before, that in terms of decisions to revoke or refuse a licence based on criminal intelligence or information, only the Commissioner of Police can make those decisions. An amendment to the Firearms Act will be that delegation comes down to me at the moment as the Assistant Commissioner. And so that coupled then with the amendment to 31 of the legislation, which is the permit to acquire, and the statement in that amendment which says that the Commissioner of Police cannot issue a PTA, which is a permit to acquire, to anyone who has been investigated for terrorism-related offences or associates with someone who has been investigated or resides with. There will be additional work for the intelligence cell or unit because of that.
So will those 3 then expand, or is 3 to accommodate that future need? As I said, so 2 of those positions are temporary for 12 months, and then they'll be reviewed. It's certainly not my intention to reduce it, and in saying that, and as a commander and a leader, you always want to look at business improvements. So another advantage that they have now is GunSafe is almost complete in terms of the modules that we have planned. So they're currently doing the last module, which is onboarding clubs. So then we'll soon have all clubs onboarded onto GunSafe. With GunSafe provides the New South Wales Police Force and then the registry with lots of data. Lots of information about people, locations, permissions to shoot, primary clubs, for which that data then we can actually start mining that with the intelligence role that we have. So when I say it's being used as more of a proactive role than what it might have been before. I see. I'll ask you about GunSafe in a moment, but just going back to these 3 intelligence analysts who will now be in the registry, will the individuals who fill those positions be trained in intelligence analysts?
There will be a requirement in the role description.
And that's in-house training that New South Wales Police provides. And are those individuals, they will have a security clearance?
Well, so every police officer or civilian has baseline security.
Yes.
So they as that have security clearance up to including protected. There is different levels of intelligence training in our organisation.
Yes.
So I think there's the sergeant, which is a police position, and then there's the two administrative intelligence roles. So between those three, I think we just need to make sure that we get the levels right, and then also in the role descriptions and what type of intelligence training is required.
So that's all a matter in progress, which are recent changes that you're implementing. For
It
the
is, yeah.
Now you referred to GunSafe. Could you give a brief description of what the GunSafe program is?
So it was created to automate, I suppose, a lot of tasks which were previously manually required to be undertook. It was a big investment in terms of budget and also resourcing. So from memory, the first module was introduced in 2019, and I think that was the dealers portal, which then allowed for acquisition and interstate transfer of firearms to be real-time updated through GunSafe from the dealer to ILS, which is our licensing system. So then we were able to, rather than the dealer having to some way notify the registry, then the registry getting that notification and manually updating ILS, it automated that. The next module was the licensing application module. And so that an applicant for a firearms license can, through customer service, gets a GunSafe account. They then make their application through GunSafe. And I suppose the beauty of that first tranche of that module was that if the right forms were uploaded, if they weren't uploaded, if the essential criteria weren't provided, so ticked off, etc., the application just didn't proceed through. And from what I understand, that prior to that, a lot of time was spent by registry staff writing back to an applicant saying, oh, you forgot to put your qualification course on, you forgot to do this. And then that's why it would just go into this cycle of communication. So that was the first part of that.
And when was that licensing application module operational in the GunSafe system?
There's add-ons within that. I think it started in 2021. And then there was a customer interaction component of that, so we could communicate with the applicant. And some of that was automated. We've received your application, again, reducing manual work. There was also then the permits and miners permits. And clubs, I think, is the final one.
Yes, I'll ask you about clubs in a moment. Just perhaps to go back a step, because you referred to the licensing application module under GunSafe. So when an online application is made with the supporting information for the genuine reason that you addressed earlier in evidence, that then has a 28-day mandatory cooling off period before anything happens on the licence application consideration front. And then the registry then proceeds in its work of assessing assessing the application by reference to the material that's been lodged online through the GovSafe portal, as it were. Is that right?
It does. So the 28-day cooling off period is legislated.
Yes.
At the time, I think the application's made. I think it's a 28-day cooling off period.
So that literally doesn't. That arrives on the desk of the customer service team, but they leave it for the period before progressing the application.
No, I don't think they do. I think they start processing the application, and getting those line items actioned.
Yes. You mentioned that all police, I think you said, have this baseline security clearance.
Mm-hmm.
With a baseline security clearance, there's still quite a lot of intelligence information that a registry officer, or in particular an adjudicator, would not be able to see. Is that right?
It depends on who puts the intelligence report on and how they classify it, I suppose.
Yep. And then how as the commander of the unit, is there a process for obtaining a higher security clearance for adjudicators? Is that done on a case-by-case basis, or is there some procedure that's in place for that?
No, I think during, when the decision to remove the intelligence role was removed, they all then had, I think it's patrol intelligence profile given to them.
I see. And
which from my understanding still gives them access up to and including protected, because it depends on who puts on the intelligence, if it's a covert unit or if they classify it as such. They still wouldn't necessarily get access to that.
Yes, I see. You've referred in paragraph 88 of your first statement to, well, this is what you say, that you note that while the police has sometimes been able to receive information from ASIO or other Commonwealth agencies, there have been challenges with the use of that information. For example, if the information was provided on the basis that it not be used in the making of an administrative decision, and you refer to it as an ongoing challenge. Can you explain that challenge or the limitations on use of information and how that might affect the operation of the registry?
So the way I personally saw that was, for example, if there is information on our system and it's been provided by a Commonwealth agency, the information might be there, but it might be caveated, and often it is caveated to say that you can't use it in administrative decisions unless you have prior approval. So that, in its sense, creates an issue for us, because we can see information but potentially not use it. And it did create some issues at NCAT in terms of what information could be used to
You're
support...
referring to the Civil and Administrative Tribunal?
Yes, to support the Commissioner's position in NCAT.
Is there not a procedure in place where the extent of any limitations on use can be ascertained by, for example, an adjudicator from the registry, following up information they can see but they're not sure if they can use?
Yeah, so they're to get permission from that agency, and I at times have had to intervene as such to make contact and seek those consent from agencies, because I suppose, I've established some relationships with those agencies, and they give proper consideration to, I suppose, the request.
In the first instance, though, that's another matter for the adjudicator himself or herself to do, to follow up with the Commonwealth Agency about the use of the information. Is that the position?
Yes.
Just to be clear about this, the difficulty that you identify is that the Commonwealth Agency might place the caveat, this information is not to be used in relation to an administrative decision, as you understand it, because the Commonwealth would not want the information to come to light in a challenge before the Civil and Administrative Appeals Tribunal relating to the decision.
That's correct.
And in practice, how you have dealt with that is to contact someone at an appropriate level of seniority in the Commonwealth Agency to explain the importance of accessing the information in order to determine an application for a gun licence. Have you been refused?
I'm just trying to think. I think there's been success and knockback, and not, being knocked back as well. So it's a bit of a mismatch.
Thank you.
Now, in your second statement, Assistant Commissioner, you have referred to, this is in answer to question 2 from paragraphs 19 and following, you've addressed the question from the Commission of explaining the process by which firearms information is provided by the police force to the ACIC for inclusion on the AFIN. So the AFIN is the Australian Firearms Information Network.
It is.
And the provision of that's supervised by ACIC, that network.
ACIC, yes.
Yes, and the firearms registry shares licensing data with ACIC for inclusion on the AFIN.
It does.
And that happens on a daily basis. In other words, there's data provided on a daily basis, so it's a rolling basis.
It is. It's updated every evening.
And that information includes, for example, the granting of a new licence, a change in the status of an existing licence, and also the registration of a firearm.
It does. I think it also does include the application being made.
Yes. And it's right that New South Wales Police draws on AFIN data itself when assessing an application.
It does.
And just in general terms, how does it do that? What does it access?
So I think if they're doing any kind of inquiry, they will generally review AFIN to see if there's any information from that they've held firearms or firearms licence in a state, and then start from there if there is that find in terms of is there more information they might need then from interstate?
And the accessibility of AFIN to registry staff includes adjudicators? To AFIN data includes adjudicators?
I believe so.
And does it extend to members of the customer service team?
I believe so. I think I've addressed that in my statement, but can I
Yes,
access that?
I can see if I can assist you with that.
Yeah, so it is accessed in, so I'm referring to 62, paragraph 62 of my first statement. Part of the systems that are used in the validation line item, which is the customer service component.
That is the customer service component?
It is.
Yeah. And so as I think 62C indicates, the validation line item includes accessing a whole lot of information in databases, including RMS, the Web COPS, the National Criminal Intelligence System database, and the Australian Firearms Information Network database.
Amongst other things,
Amongst
yes.
others. Now, gun clubs are required by Regulation 100, I think they're now called Section 100 of Firearms Regulation 2017, to provide certain information to New South Wales Police in an annual return.
They are.
That information includes the membership details for the club. Is that right?
It does if there's a change in membership details.
Right.
A change in membership details and also participation requirements.
Sorry, is also...
Participation requirements.
Yes. And those annual returns can be submitted at present either through the gun safe system or just sent separately via email.
Yeah, so as I briefly touched on before, we are onboarding clubs onto GunSafe, and up until I think this point, or maybe at the time of my statement actually, we've onboarded, I think it was around 85 clubs out of around 580 clubs. If they are onboarded, they then provide their yearly returns on GunSafe. And obviously the idea is that we get all clubs on GunSafe, so then we can automate some of that review and audit.
Sorry, what was the last thing you said? I just didn't...
Review and audit?
And review and audit
Yeah.
the information. Yeah. At the moment, you have indicated in your third statement, so as of very recently in May, you've identified that 97 clubs out of 581 have been onboarded onto GunSafe.
Sorry, what paragraph was that?
I'm looking at 24 and 25 of your third. Statement. In paragraph 24, you indicate that there are 581
Yes.
clubs in New South Wales which between them hold 1,036 shooting club, hunting club and collectors club approvals.
Yes, that's right.
And at the present time, 97 clubs, which accounts for 172 approvals, have been onboarded onto the GunSafe system.
That's correct.
When is it anticipated that will hit the full amount of the clubs in New South Wales?
I've been guaranteed 3 times.
Who's providing
by the
this guarantee?
commander of the firearms registry that will be achieved by the end of the year, and I suppose to support that, I think there's 2 additional temporary staff, or 2 temporary positions were created in March to assist in speeding that along.
Yes. Now, once a gun club is brought onto the gun safe system, can I just ask you about some of the consequences that might have for provision of information to the registry that might be of utility in respect of licensing and applications generally? The clubs will still be required to provide the annual return
They will.
through
They
the
will.
system.
Mhm.
The annual return is intended or is required to include any identification of non-compliance by members of the gun club with the requirements on them. Is that right?
Yes. So, yeah, sorry, I'm not sure if this is what you're asking, but the actual firearms licence holder can have multiple clubs that they're members of. They provide us with their primary club,
Yes.
and it is their responsibility to update their primary club that they have undertaken activities in other clubs, so that that primary club can update their records to say that they've achieved their yearly accreditations.
And what sort of non-compliances have to be noted in a club's annual return? In other words, non-compliances by members.
So that's particularised in the regulations depending on the club type.
What are some examples?
So recreational hunting clubs, I think they're required to do 2 hunting activities per year. For other, like a sports target club, there may be, I think maybe 4 a year. So it just depends on the club and the licence.
So which is intended to identify that for individual members they are actually taking advantage of the club's facilities to use the firearm in the authorised way.
Well, and it's, I suppose primarily it's used to confirm their genuine reason.
Yes. Now there's a National Firearms Register project, and the Firearms Registry is participating in that project.
It is?
Could you outline some of the current steps that are involved in that?
So the National Firearms Register will, I think the expected commencement is in mid-2028. So New South Wales Firearms Registry, though, is, I don't know how to put this without bragging, but we are leading the way in terms of meeting certain timelines for the NFR, if I can call it that. The first, I suppose, goals to be achieved like this. So there's an agreement in terms of classification of firearms, etc. So we had to do a data cleanse of all of our firearms to make sure then across nationally that if we refer to a firearm as something, that's consistent across the country. So that has been an enormous, I suppose, component of we're still through that part of the process. But the reason why I think we are in a better position is because of GunSafe and the automation of that. So there are still some states who either have a partial licensing system or still use paper-based.
There still are jurisdictions in Australia that are entirely paper-based when it comes to a firearms registry.
Yeah, that's my understanding.
Facility. when there is movement by a greater proportion of gun clubs to the gun safe platform, then is it the intention that in due course will form part of what's synchronised with the National Firearms Registry?
I believe that's being explored, yes. There's still obviously components of the NFR which still need to be worked out. I know in terms of licence holder details, firearms licence details, transactions, movements, all that kind of thing will be on there. I just can't confirm at this point in time if club information is being considered, and if it's not, then I believe it still could be considered because it's not finalised.
So, in other words, the precise functionality of the system that the National Firearms Registry might in due course adopt may or may not have the same sort of scope and functionality as the gun safe program does in New South Wales. That's a matter for further consideration. Is that right?
Well, that there may have to be, obviously we need to link our system into what the NFR will be, and so that might mean system enhancements for our gun safe for that to be able to occur.
The operation of GunSafe in respect of information coming via the annual return from clubs is obviously enough an annual provision of data. At the moment, is there any more frequent or routine engagement with gun clubs by the Firearms Registry in the course of a consideration of a firearms application or an application under the Firearms Act?
I'd probably say not so much in the application part of the process, but more so in current licence holders. We would and do make contact with clubs if we're seeking information to confirm that they've done their yearly requirements, because again, there's that, I suppose, confirmation that they've confirmed with their primary club that they've done it in other clubs. So there's still, that needs to be confirmed.
So would that be a matter of say, an adjudicator, or this is not an adjudicator, this is some other function within the Firearms Registry, contacting the gun club specifically to say, we just want to check on some of the data in your annual return?
No, it is done probably at times in the renewal process, which could be the adjudicator. But more so if something has flagged for a firearms licence holder, and in terms of some other information, and then we want to gain a more fulsome picture.
So one of the genuine reasons that I've addressed a couple of questions to you about is, or one way to substantiate a genuine reason is to prove, for example, you're a member of a hunting club and that you've met participation requirements in respect of that. Correct?
So for an application, they have to provide their membership details, but obviously because they don't have a licence yet, they wouldn't have been able to.
Yes.
Yeah.
No, but does the Firearms Registry routinely engage with gun clubs for the purpose of that first involvement by an applicant, in other words, the initial application under the Act?
Not per se. We have a good relationship with clubs, and so I think information flow either way is I suppose encouraged by both police and clubs. So on one hand, if clubs had some concern about someone who might have done, you know, a P650 try shooting, where they can go and see if they like it. They do, and they can provide the registry with some information about those concerns.
Yeah. So, but absent the gun club noticing something that looks odd and getting in touch with the registry, in the ordinary case of an application, it would not be the procedure of the registry to make contact with the particular gun club that the applicant says is their genuine reason for applying for a licence.
No.
Do you think it'd be useful if registry staff did that in each instance? Would that give some further assurance to the process?
I'm just trying to think how that would be implemented. Obviously, as I'm thinking through that, it's not something that I can sit here and say no, because I have any chance to get to improve, we will. So, you know, if that's something which we could consider in terms of how that might look, we will consider that.
You've the information that might be provided to the registry by gun clubs fulfilling their annual return obligations, that there's no barrier of which you're aware, is this right, for that information to be shared by New South Wales Police and by the Firearms Registry with Commonwealth agencies?
Legally, I don't believe so, but that's just my understanding at this point in time. I don't believe so. It would be more so capability in terms of systems.
As in getting the systems in place to enable that to occur?
Yes.
In a way that doesn't consume all of your available resources? From your position as commander, do you consider that information about a person being a member of a gun club and related information as to their activities there could be useful intelligence for intelligence and law enforcement purposes?
Yes.
The Commonwealth has introduced the legislation combating anti-Semitism, hate and extremism, the Firearms and Customs Law Act of 2026, and you refer to that in your first statement.
Yes.
That establishes a framework for background checks that are proposed to be undertaken by AusCheck.
Yes.
And you've indicated in your first statement that the preference of New South Wales for police is for a positive check under AusCheck to be a precondition to a licence application progressing.
Yes.
Could you explain that position of the police?
So that preference would be that as a precondition that if a positive is not received, then we don't take it any further. So I suppose it's in terms of administrating applications, if that's a knockout, then we're not wasting resources when at a point in time if we get that later. So that's why that would be our preference.
So that would be one of the very first system checks that's carried
Yes.
out on an applicant for a licence.
Yes.
And would that involve any substantial change to the structure of the firearm register to bring that kind of check on board? Would that be relatively straightforward?
It's difficult to say when it comes to technology.
That's true.
And the exact, I suppose, details of that, we are working with the Commonwealth still on that. So it depends on both, I think.
Thanks, Assistant Commissioner. No further questions. In the open session. I will see you tomorrow.
Ms Munro?
One question. Assistant Commissioner, my name is Munro. I represent the Commonwealth. In paragraph 88 of your statement, you were asked some questions by Senior Counsel Assisting and then some further questions by Commissioner Bell.
Mm-hmm.
In paragraph 80, you refer to sometimes challenges in relation to the use of information, and then I think it was characterised as caveats on use of the information. Commissioner Bell put to you that in practice how you have dealt with that is to contact someone at an appropriate level of seniority in the Commonwealth agency to explain the importance of accessing the information in order to determine an application for gun licence. And the transcript doesn't record it, but I think you agreed with that characterisation, is that right?
Yes.
And another option, is it correct that another option is that since mid-2004, you could have, mid-2024, you could have also requested that ASIO undertake a security assessment under the ASIO Act?
Is that also the case?
Yes, you would agree with me that that was another option to use the information.
I suppose from my involvement, when it was escalated to me, that's the process which I undertook, and I suppose at that point in time, the specific one I'm remembering now was actually an FPO, so a firearms prohibition order. So I directly contacted because of the urgency of the request.
Yes, and another option would be to have obtained a security assessment under the ASIO Act.
I haven't looked at that specific avenue, to be honest with you.
Thank you, Assistant Commissioner. No further questions.
Thank you. Yes.
No
Ms. Sharp?
questions.
Right. Ms Edwards?
Oh, Commissioner, we don't have questions today, but we've foreshadowed with the assisting team we may seek leave to ask questions later, given that we received some information this morning that my client could have access to, and we're still waiting on other information to be provided.
Yes. Well, very well, Ms Edward. You can make an application in due course, and I'll consider it based on the information that you provide. Thank you. Yes. Very well. Well, I'm going to give us an early mark, and we will resume at 2 p.m, and that will be in closed session. I'll now adjourn.